computer is deciding to have a little bit of a freak-out day, but I'm going to see if it will cooperate, I think, from now on, at least for the most part. So welcome back, Legal Studies 160. This will be lecture 12, although I'm going to start a little bit back in yesterday's lecture. Let me just say, looking ahead to next week, and your midterm, which again, a reminder, this time next week on Thursday will be your midterm right in this room. If you're listening at home, you can take the afternoon off. There will not be a webcast. All you hear is groans and moans anyway, so you won't enjoy it. In any event, in terms of coverage, I do want to clarify, just to perhaps give you a little bit more of a head start or comfort level on your studying. We're going to consider this class to be the cutoff class in terms of what will be covered on the midterm. So we will not, although we will talk a bit about the death penalty on Tuesday, and it'll be to some extent give you a chance to review some of the concepts that we've been talking about. We will not, the material that gets covered, the new material that is covered on Tuesday, will not be on the midterm. The other thing I wanted to say in terms of things that you can, as you're prepping, a number of people just sort of ask me what kind of stuff they should be studying. I want to repeat, I think what I've already said, that sort of my lectures and the required readings are the key. I understand there may be a required reading or two that has not been up appropriately on the website. Don't worry about that. If anything that's not up, first of all, we'll get it up. But if it hasn't been up, you won't be accountable for it on the midterm. There's a couple things for the weeks coming up that we'll get up there. So if you've checked, check back after the weekend. In addition to the readings in general that are required and my lectures, notice that we've covered a lot of cases in the class. And while we haven't always talked extensively about all the details of those cases, you should be in a position, you should have read those cases, and you should be able to explain, at least roughly speaking, what they're about, what they hold. This isn't a law class. You're not accountable for your understanding of the legal doctrines, particularly, that are at work there. Although we've tried, and we've been exploring the Eighth Amendment a lot in this section, and we'll continue to. But so pay attention to those cases. You can expect some questions about cases that will require you to know what happened in the case, and at least in broad strokes, what it was about. So let me just stop and ask if I can answer any other questions about the midterm. Yeah. Still working on exactly whether it be multiple choice or short answer. I think to be safe, bring a couple of blue books with you. It's not going to be a long essay type test, but I don't think we any longer have the kind of readers that scan Scantron sheets. So even if it is multiple choice, you'll probably be writing that in a blue book with your name on it, etc. So bring a couple of blue books, pencils or pens, and you'll be sure to have what you need. Tony. Okay, that'll be great. Is that a required or a recommended reading? Okay, so you won't be responsible for that particular reading as a required reading because it is just going up now, but it'll be there for your review. It pretty much covers a lot of things we'll be talking about today. Okay, so let me take you back to our discussion of America's close brush with abolition, with complete abolition in Furman, and then what unfolded afterwards. I want to talk about the Gregg versus Georgia case and the regime that came out of that. But I just want to go back for a moment. We talked about the distinctive American, if we're looking at America in comparison to Europe in the 1960s and 70s, a lot of similarities in terms of the way the death penalty debate is shaping up. As in Europe, you've got a gradual winding down of less and less use of the death penalty. You've got some growth of public support for abolition, although it's barely a majority at its most, or it's sort of a 50-50 split. You've got a liberalizing tendency in the country, which we saw is at least a recurrent factor where abolition took place in Europe. You tend to get a shift to the left, either a move away from authoritarian governments, as you had in Spain and Portugal, or a shift to the left, as in the socialist government in France. In the United States, the 60s was generally a shift toward more liberal values, civil rights values, anti-discrimination values. So again, a very similar context for abolition in the United States. The big difference, of course, is whereas European countries resolve this in their parliaments or assemblies through essentially majoritarian institutions, even though there was no majority popular support, but these majoritarian institutions did the work. In the United States, the issue was brought to federal court, as many issues at that period were. Issues like school desegregation, abortion. Some of your legal studies majors will know that a great deal of American public policy in the last 40 years has come through and to court. And before we sort of talk more about because in some ways the history of the American death penalty from this point on is a history of major court decisions, I just want to call on some of the legal studies majors in the audience here to tell me a little bit about what are the advantages and disadvantages? What are the consequences, for abolitionists, both good and bad, right? Looking at it from the perspective of the people who go to court seeking an abolition. What are the advantages of a court-based strategy as opposed to what happened in Europe, where you're working through majority parties in parliament? Yeah.
It's like a lot more permanent, it's a lot harder to reverse.
So if you win, right? If you win in court, then the prize can be a very big one indeed, because it tends to say, the court is acting. It's not acting because it thinks that the death penalty is a bad idea. It's acting because it now believes the death penalty is unconstitutional, right? And if it finds that, then unless the people actually amend the Constitution, which can be done, but as you know, there's only been about 25 amendments in our whole history, so it's not easy to accomplish an amendment. It's pretty permanent. So that's one. Count that as a plus, right? I said last time that if they had only gotten 2 more votes, this issue would be sort of like abortion. It would be maybe a culture war about it, but it wouldn't really affect state law nearly as much, obviously, as the consequence of not having overturned it. So you do get permanence. What else? Yes.
Well, Steve, but I think more important than that is that you do it with one person, as opposed to when you're trying to change policy, it takes tons of people, often the majority, and swaying opinions of lots of representatives, whereas you have one man.
Or even a woman.
Or woman, yeah.
And so, but you make kind of 2 points there, right? One is that courts, unique compared to parliaments, are places where you can get a hearing sort of without having a great amount of political clout. Now, whether a single person can do it or not, obviously you need to win the cooperation of lawyers. I mean, most of us are not equipped to go to court, and the Supreme Court actually is not open to us as pro se litigants. We need lawyers to represent us. So it's a little bit more complicated than just one person get the voice. But certainly compared to what it takes to change a parliament, where you have to have sort of majority strength, maybe not majority that is opposed to the death penalty, but a majority that puts that party in power, as say the socialists in France in 1981 under Mitterrand. Whereas with the court, it's the classic venue for minorities, right? That's why so many issues like school desegregation, which have involved minorities challenging democratic institutions that have been discriminatory to them, have gone to court. So that's certainly a great advantage of it. But you also mentioned speed. Is speed something we associate with court-based reforms? When the Supreme Court decided Brown versus Board of Education in 1954, they in their second ruling about a year later, they said that desegregation should proceed with, quote, all deliberate speed. And there's whole books. You probably read some of the books like The Hollow Hope and whatnot. And basically, the pretty clear history that we have now is that a decade after Brown, say 1964, virtually no desegregation had taken place in the United States. Now, there was not a huge surge forward as Congress got into the act with the Civil Rights Act of 1964. And you might argue, and I would actually support this argument, that the court battle was crucial to actually creating the politics ultimately for the Civil Rights Act of 1964 to pass. So I don't want to say that courts, that's a failed strategy. But it's not a quick strategy. And indeed, one of the problems for the death penalty opponents in this go to court story is it took a while to queue this up. They started trying to get the right case in front of the Supreme Court in the early 60s at a time when opposition to the death penalty was growing. Liberalism was generally triumphant. LBJ won a landslide victory as a sort of full-throated liberal in 1964. So a lot of the momentum seemed to be on their side. By the time Furman gets to the Supreme Court in 1972, it's a very different landscape. Richard Nixon has been reelected overwhelmingly as a conservative. You got a real rise of conservative politics in America. Civil rights is to some extent on the wane. And of course, fear of crime, which is a very big issue by the late 60s and early 70s, but wasn't so much a concern in the early 60s, has changed things. So speed tends to hurt, or be a cost, if you will, of going to court. What other costs and benefits do you see to a court-based approach to abolition? Yeah.
I guess a variation of the front thing is the addition of new judges.
So, unless you win outright, there is always the risk that your progress will slip away as new judges come on. And certainly Richard Nixon was appointing judges that were more pro-death penalty. In fact, it becomes a kind of litmus test, right, for politicians then as to whether they're going to appoint somebody. Yeah. And it's interesting, right? Because one thing we know pretty clearly is that of the vast majority, well, America in 1971, 72 was split on the death penalty with a resurgent majority in favor of it. The Supreme Court, if you had actually just asked the men, it was all men, unfortunately, at that moment in our history, where they stood on the death penalty, pretty much 8 of the 9 were personally opposed to the death penalty, even in Gregg. So you got, it's a smaller audience, and it's one because they're very educated, very elite in their cultural values. They're the kind of people who, we've seen from Beccaria on, are sort of drawn to the human rights arguments and these more philosophical justifications. So that is an advantage. If you can persuade 5 of these 9 people wearing robes, then you prevail. Even if your polling numbers are 1 or 2% out there in the general public, you still win. So that's very attractive. Now, one of the downsides, and I think you can see that in all the cases that we were looking at for yesterday and today, your arguments change once you are in court. You're no longer making full-throated arguments about the immorality of the death penalty, or if you are, you're having to couch it in terms of whether or not it's no longer acceptable to American values in a very broad way. Many of your arguments are highly necessarily oriented toward law itself, the arbitrariness of the death penalty, the wide discretion given to jurors, the problems with the procedures and the hearings, etc. So you're moving from sort of broad philosophical and public policy arguments, which you might think of as sort of better made to a legislature, toward more legalistic arguments. But some new arguments come along that had not been part of the death penalty story earlier, including, of course, race discrimination, very importantly. Let me skip back to my story and talk a little bit about the Gregg decision. Actually, let me stop on the backlash slide that I talked a little bit about last time. Furman comes down, and literally within 3 months of the decision, I think it's July, the very end of June is the decision. As you may know, the Supreme Court announces all of its decisions by the time it usually closes for the year at the end of June. The last week in June is usually when you get these very big decisions, so that's probably when it came down, the very last week in June, 1972. By that fall, right, which is an election year, by the way, fall 1972, so I shouldn't have said Nixon had been reelected. He was on his way to a triumphant, overwhelming reelection. But by that fall, with campaigning in full swing, you had a huge number of states that had already reenacted death penalties, and so you have this great surge. And we talked a bit about this last time, but I just wanted to point to sort of 3, just as the legal battle to abolish the death penalty brought new arguments into the death penalty context that hadn't been there before, this response to the court decision also brought, in some ways, new arguments and a new social activist aspect to the story. Up to this point in history, the sort of activist front was all about abolition. The death penalty was the status quo, right? And so you didn't have to be an activist to support the death penalty. It's just the way things were. The activists were the people who wanted to shut down the death penalty. Now, with the Supreme Court's decision, which appeared to be striking, it certainly struck down all existing death penalties, and to some readers, it looked like it might be the end of the death penalty. This sparked an outrage and a sense of activism on the part of those people who supported the death penalty. So for the first time in history, you get a sort of activist retention movement, and that's been very significant. And this movement began to articulate a number of values that have stayed with the death penalty ever since, for better or for worse, in terms of its larger cultural standing. One of those issues has been states' rights. Once you go to court, and once you go to federal court, a big issue is going to be whether or not this is a question on which national values ought to trump state values, because states have the primary responsibility for criminal justice in our legal system. And as you saw from Gregg, one of the big concerns of the Supreme Court in accepting the new death penalty statutes was wanting to defer to those state legislatures and make sure that the court was not usurping the role of states in deciding on criminal justice policy. Now, states' rights had a kind of nasty edge to it in the 60s and 70s because of its association with segregation. Supported, if you've seen The Help, the world of Jackson, Mississippi in the early 60s is the world where people, when they say the word states' rights or the phrase states' rights, they really mean we don't want federal courts telling us how to treat black people, is basically what that means at that time. And so one of the things that the death penalty does is give states' rights a new, much more neutral kind of expression. This isn't something that just southern states are upset about. It's states like California, which is one of the first states to enact a new death penalty law, and indeed one of the few that has a voter initiative. Nonetheless, there is a strong southern twist to the death penalty response. My former home state of Florida, I think, was one of the very first states. They called an emergency session, I think, within a week of Furman and reenacted the death penalty. And there was certainly a cultural sense that, along with Brown, that Furman was a kind of attack on the Southern way of life. After all, it was Georgia that was the named defendant in Furman versus Georgia. It was predominantly Southern states that were using the death penalty at that point in history. And so, in many respects, the death penalty retention surge had a lot of overlap with essentially conservative reaction in the South to federalization of civil rights law more generally. But if it had only been that, it's not clear to me, at least, that the retention surge would have gone far enough. If it had been only a Southern reaction to the death penalty, if folks in the Midwest and the West and the Northeast had kind of said, we're done with the death penalty, if it had remained a Southern regional phenomenon, it's very likely that the Supreme Court would have been far more suspicious of the new statutes that came back, and over time, perhaps, decided eventually to strike it down altogether. But it was not limited to the South. It was all over the country. And while some areas that had traditionally been abolitionists, like the Northeast and the Midwest, were slower to reenact the death penalty, and in some cases never did reenact it, mostly states that had abolished it well before Furman. States like California, Arizona, Washington, Western states, Sunbelt states outside of the South, all embraced the death penalty. And for many of these states that did not have a traditional sort of racial cast to the notion of the death penalty, it was less about a Southern way of life or even just states' rights, as it was about fear of crime. When the death penalty was moving to court in the early 60s, crime rates were still relatively low, and the public was not alarmed by crime. By the beginning of the 70s, fear of crime was maybe the biggest issue next to Vietnam facing American life, and murder in particular had gone through the roof. Basically, homicides tripled in California between 1960 and 1980. And you can imagine how this then hurt the death penalty abolition cause. You had, in a sense, a decade of de facto abolition, And you might have, supporters of the death penalty abolition would have hoped that they'd be in a position to turn around and go, see, we told you, we didn't have the death penalty for most of this decade, and it didn't cause crime to go up. Well, unfortunately for them, I'm not saying it did cause crime to go up, but the absence of the death penalty went along with a decade in which crime rates were surging up. So that seems to certainly provide, again, some empirical support to the fear that the death penalty had been actually an important component. And that is another theme. The death penalty after Furman becomes firmly associated with support for law and order. Right? Up until this point, lots of people who were opposed to the death penalty also considered themselves essentially strong on law and order, and would make the argument that the death penalty is not really effective as a tool of law and order. After this point, people who are concerned with law and order tend to emphasize the support for the death penalty. People who oppose the death penalty tend to at least be perceived as soft on crime and not supportive of law and order. So all of that is set into place and becomes part of the new framework of death penalty politics and life in America. So let's talk about Gregg for a moment. The same court that decided Furman decided Gregg. As I outlined last time, the arguments that prevailed in Gregg were not surprising given what had happened. The claim that the death penalty was no longer popular or in line with American values had been very decisively apparently rejected by the American response to Furman. The majority in Gregg did ask the question as to whether the death penalty could be adequately justified based on core purposes of punishment. They basically accepted the argument that if the death penalty did not serve any true penological purpose, that it might in fact be unconstitutional, but they pointed to two, retribution and deterrence, as ones that supported the death penalty. And this has been an important feature of the death penalty's legal standing ever since. These purposes, retribution and deterrence, are the core ones. The Supreme Court has basically said, unless the death penalty in a particular case or category of cases serves these purposes, then it would probably be unconstitutional if it did not, if it could not be shown. Other purposes like incapacitation or rehabilitation are not seen as sufficient to justify the death penalty, largely because prison would appear to accomplish the same goals. The case for the death penalty, which the Supreme Court accepted largely in Gregg, is that when it comes to retribution and deterrence, there is something, in a sense, irreplaceable about the death penalty. That if you can't execute at least some murders, then there'll be a sense in which the public's expression of outrage will not be effectively communicated. That's the point about retribution. And deterrence, while acknowledging that there was a lot of controversy as to whether deterrence really worked, the court in a sense accepted that deterrence, at least for some people, must work. They opined, we may nevertheless assume safely that there are murderers, such as those who act in passion for whom the threat of death has little or no deterrent effect, but for many others the death penalty undoubtedly is a significant deterrent. Now, if you read the opinion carefully, it's not quite clear how they get to the undoubtedly. It comes close to being an axiom to them, that if the death penalty is, if people fear death, then it must be that at least some people who would otherwise not be deterred by the prospect of a long spell in prison, perhaps life, would nonetheless be deterred by death. The other important and predictable, I suppose, doctrinal move in Gregg was to take the concern in Furman that the death penalty was being imposed in arbitrary and capricious ways, and basically look at the new statutes, such as the one in Gregg, in Georgia, I should say itself, and opine that at least on the face, these looked like statutes that would address the problem of arbitrariness through the procedures that we talked a bit about last time, bifurcating the trial, the guilt phase and the sentencing phase, narrowing the grounds on which the death penalty could be given to certain aggravating factors, the process known as statutory narrowing, allowing appeals and requiring them automatically to the state Supreme Court. And indeed, many statutes at the time, like Georgia's, gave the Supreme Court the duty to assess not only whether there was legal error in the trial below, but also whether the death penalty was proportionate in that particular case to the crime. An analysis that would require the court to look at other murder cases in the state and see if they were sort of consistent with a death penalty in that decision. In one of the companion cases to Gregg, Woodson versus North Carolina, the Supreme Court held that even though they acknowledged it was good for the statutes to narrow the discretion of the jury, they could not take it away altogether by creating a mandatory death penalty. Right? If you really wanted to make sure there was no arbitrariness, a mandatory death penalty would seem very attractive. But the Supreme Court in Woodson versus North Carolina held that would essentially violate the defendant's right to have to have consideration. That was elaborated on a couple years after Gregg and its companion cases in the decision called Lockett versus Ohio, where the Supreme Court, and by the way, these cases I'm mentioning, like Lockett and Woodson, are not ones that I'm going to hold you accountable for knowing the holdings of. They're just illustrative of the framework I'm outlining for you that emerged after Gregg. Lockett stood for the proposition that defendants ought to be able to present almost any kind of evidence that could be mitigating, that is, that could lead a jury to want to spare their life. Most of these statutes, like Georgia's in the Gregg case, basically gave the jury a bunch of aggravating factors, factors that made a homicide worthy of the ultimate sanction of death. You might think of that as sort of the worst factors, right? If everybody who commits murder is the worst, but who's the worst of the worst? These aggravating factors are going to pull those worst of the worst out. But then the mitigating factors come in, and the jury is supposed to kind of decide, given what I know about this person, maybe they were suffering from a mental illness, maybe they were provoked by the victim in some way, etc. Does that convince me that the person maybe should be extended some mercy on this occasion? The jury, the Supreme Court held in Lockett that basically the jury's ability to consider virtually anything that would be mitigating should not be limited by the state having a list of mitigating factors. So Gregg gives us very much at least in broad outlines, the new framework of the death penalty. And in a sense, what I want to do for the rest of the time is sort of compare this new death penalty, not the old death penalty, but this new improved death penalty, in a sense, to the abolition situation in Europe. And just to telegraph where I'm going, right? We began on Tuesday by saying, well, why is America so exceptional? Europe, our supposed close cultural and economic and social match in the world, has universally abolished the death penalty, basically, at this point. We have it. What explains that? What I want to suggest to you now is that there's more similarity than difference here, that both countries, both Europe and the United States, obviously Europe is not a country, it's a collection of countries,